For those of us who just come on, the Finance Committee is now back into open session at the moment. The committee is receiving an oral briefing on the RHI disciplinary process. In front of us we have Colin Boyle, who's the Interim and Permanent Secretary, Jill Min, who's Head of the Northern Ireland Civil Service HR and Strategic HR Directory, and Hugh Wittes is the Departmental Solicitor. We've already in closed session, we have discussed some of the issues, but there are some other issues that we will go and talk about now in open session, and we have determined that there is no particular issues that we have said so far that could have warranted us remaining in confidential session. I think that is quite clear. Question I have to Colin, would you like to make some remarks, and then I'll open it up again to the committee for some specific areas. And when your remarks, one of the things I would like you to discuss is the issue of misconduct and what is actually meant by the definition of misconduct and how that was determined, particularly amongst the officials who were determined to have who have actually breached the rules and ended up in misconduct, because I'm not quite sure what is defined by misconduct.
Okay. Well, the definition of what we define by misconduct will be set out. It's set out in our. There would be examples of that set out in our staff code and handbook, in terms of the disciplinary procedure. Jill, you maybe have a copy. We'll cover that in a moment or two. So, just in terms of my opening comments on that, I know you already have my brief, so I'm not going to slavishly read through that. We've covered a lot of the ground in that. I just want to thank the committee for the opportunity to attend today to discuss these issues. I recognise the very significant importance of them, hugely important, and we're very cognisant of the terms of reference of the inquiry, that it should examine the role of ministers, special advisors, civil servants and any others involved in the RHI scheme, including external consultants. And we know that the inquiry looked at their actions across a range of standards, including Nolan Principles, Ministerial Code of Conduct, Civil Service Code of Conduct and the Code of Conduct for Special Advisors. One of the things for me coming fresh to this, and I watched this from afar when I was in other departments as to what was happening with the RHI, and I watched the dispatches on the news or listened to them on the way home from work many evenings in terms of what was probably some of the very sensational stuff that was emerging from the inquiry in terms of the tone of it and in terms of the way it was publicised. All of the detail of the inquiry wasn't what the disciplinary panels were meant to look at. What the disciplinary panels were meant to look at, what they did look at, was what the findings of the inquiry were. And they were required to pick out from the findings what constituted, in their view, discipline in respect of conduct in relation to their conditions of employment. I accept that the inquiry findings themselves do not.
Just a quick one. Is there degrees of misconduct are looked at within the civil service, like severe misconduct, medium levels, or whatever happens to be?
Yeah, there's a gradation. There's a gradation, and in terms of what constitutes under, which sits by way of examples under each category. You know, the examples, you can give some examples, but it can vary. But things like gross misconduct, for example, would be the worst, which have proven would be could warrant someone's dismissal, for example.
Were there any examples of gross misconduct? Because what we don't have, we've been told there was levels of misconduct. We haven't been told the levels. Were there any examples of gross misconduct that were found?
I don't know. I wasn't involved in the disciplinary. That disciplinary process is closed to the people who were involved in the disciplinary process. So the people who were party to that are those investigating officers and those decision officers. And Jill's already covered in terms of there were a number of people on the external panel and there were a number of people on the internal panel, and it was for them to weigh up, particularly in terms of the internal panel, to weigh up the evidence, weigh up any outcomes of investigations and make their judgments about what the severity of the offence was and therefore what level of discipline that actually warranted.
Would it be useful, I think it would be useful if the committee saw a breakdown of those who were placed under misconduct, at what levels of misconduct they were, because obviously we're presuming, because we don't know, that these were all examples of gross misconduct, but if we haven't been informed of that, it might be useful just to see where that is.
Yeah, well, I don't know. I've never seen that information either, so I don't know and nor should I have gone to look for that information, so it wasn't pertinent to what I've been asked to do in my role. But one of the things that was very striking for me in terms of Sir Patrick's findings was, and I'm not saying this, I'm not quoting this to allay any or downplay anything that happened, but I think it captures for me the essence of one of the reasons why perhaps we've had the outcomes that we have. Responsibility, I'm quoting from the findings, responsibility for what went wrong lay not just with one individual or group, but with a broad range of persons and organisations involved across a variety of areas relating to the design, approval, management and administration of the RHI scheme through its life. Across these areas there was a multiplicity of errors and omissions, including but by no means limited to those referred to in the summary above. In addition, there were repeated missed opportunities to identify and correct or seek to have others correct the flaws in the scheme. The sad reality is that in addition to a significant number of individual shortcomings, the very governance, management and communication systems which in these circumstances should have provided early warning of impending problems and fail-safes against such problems proved inadequate. And what that suggests to me very clearly is this is not about a smoking gun of someone's misconduct. This is much more about the generic capability of the civil service to manage itself and to manage change and to manage large, high-profile risk projects. That's what that conveys to me. I'll also quote from an earlier piece on para 38 of the findings. Corrupt or malicious activity on the part of the officials, ministers or special advisers was not the cause of what went wrong. So in terms of the cause of what went wrong here, my view will be, okay, is this a capability issue, a capacity issue, or is this a conduct issue? So if you have a disciplinary process which is looking at a conduct issue, when you read the findings from Sir Patrick, on one level it may not be a surprise that we have findings of, or outcomes of the nature that we have. This is, for me, an awful lot more about the capacity and capability of the civil service and the collective than it is about the feelings of individuals. And I do accept there were feelings of individuals. I'm not whitewashing anything.
There are sort of three distinct chunks here if we look at RHI. One is a cultural issue. One is the cultural issue of the Northern Ireland Civil Service and the interrelationship it had with the government at the time. And that created a lot of feelings, and we know that that's been reported by the report as well. That was very clear. The second issue is one of what you would call normal checks, balances, and controls. Because, I sat in the Economy Committee and was told that there were the checks and balances controls should have picked up on these systems. And we know from the RHI inquiry that the normal checks, balances, controls did not happen. So it's not just a question of the system. It's not a question only of the culture of the system. It was the fact that even the systems that were in place weren't picking up on that, and there was a reason for that. And there was a third issue, and I think this is the question where it comes to culpability, and this is what we haven't really heard. So the real concerns about sort of departmental officials who were contacting people in industry. And that was picked up during the RHI as well. And that's quite clear that there were particular individuals who were responsible for that sort of activity. Yet, look across the whole spectrum of everything that happened, bearing in mind this place came down for 3 years, bearing in mind it's fundamentally undermined people's understandings and support even the principles of democracy here in Northern Ireland. There's only one person who has been disciplined out of the whole process. So I hear what you say about there is a wider issue here. Well, it's been quite a considerable period of time since the RHI report has come, and we still haven't had seen any of the practical outcomings of that. We have the second issue about how do we make sure that the checks and balances control that are there and should be there are being followed? Because we haven't seen that. We didn't see that during RHI. There was normal accounting processes. There was people who were responsible as accounting officers. There were people who were responsibility for finance. There were people who should have been doing even the basics. That wasn't happening. And that is the normal checks and balances systems as well. And the third point is there's a degree of sort of culpability. And I find it quite difficult, even at this stage, to be told that there was only one person who was in any way deemed from the civil service who has anyway been disciplined for this. And this is one of the problems that I have. So could you identify those 3 specific areas? The cultural piece, I think, Colin, you've already talked about. The normal routine management, I'd like sort of some answers about that one. And then the other one was, how do we deal with this sort of, this is the bit I can't understand. We know that, let's be quite frank, it sounded like insider trading to me. And I think if we were in the City of London, that's precisely how it would have looked. So if you could identify those 3 things, and then we'll move on to the other committee members to do that.
Okay, well, in terms of the checks, balances and controls piece, when I look at that and I read not just the findings from RHI, but what NIAO have picked up from it in terms of the capability and capacity piece, and I think they picked that up very well. Whenever you see teams of people changing in very, very short paces of time, when you see handover arrangements not being operated the way that we would like, when you see an organisation, even the size of the civil service, where there have been significant staffing reductions, but maybe where there hasn't really been the level of development of professional expertise in specific professions the way that we would like. So we know, for example, commercial expertise, project management expertise, programme management expertise. Those are things where I think the shortcomings have clearly been identified. So I don't believe that people were acting malevolently or to do the system down. I think there's issues about the level of competence that people have. When you work a grade-based system as we do, and people move in and out of jobs, and there's a belief that they will, by osmosis or by sitting by Nelly, that they will be able to pick up the level of expertise that they require to do that job. I think that for us is one of the biggest lessons in this. So I think having the right people in the right jobs at the right time is a phrase that we use now every single day virtually, but it's about having people with the right technical skills to do those jobs. And I know at one stage we would have been very heavily criticised as a civil service because of the heavy reliance on consultants to do a lot of those technical types of jobs on our behalf. I think there's a significant challenge on our part to make sure that we balance off what we do internally and what happens externally. And when we do actually recruit or procure anything from an external point of view, we do look for that knowledge transfer. I think we have a way to travel, Chair, to get ourselves to the place where we have full confidence that we've addressed all of the issues that RHI and the challenges that it presents. You mentioned the cultural piece. The cultural piece pervades all of this, but it pervades the very grade-based system that we actually have. And I think there's a huge challenge of marrying off what grade-based means and the various policy jobs that people do versus the technical, professional technical roles that people play as well. So there's a sweet spot to be hit with that we haven't quite got there yet. And I think the capacity and capability report picks up on that very appropriately. In terms of the insider trading piece that you mentioned, I'm alive to the issue that you refer to. I don't know what happened in the disciplinary process. I don't know what views the people in the external panel and the internal panel took. I have a great belief in the disciplinary process. I know that the individuals were chosen in terms of their reputation, in terms of their capability, in terms of their seniority, in terms of their skill set to sit on the external panel. And I know that the same thing was done in terms of picking up unconflicted permanent secretaries, again with a good solid track record, to make sure that people would fulfil their responsibilities in relation to this process of discipline. So I can't comment on who didn't get disciplined, who might have got disciplined, what mitigations they might have come up with. I don't know what the scenario was that they were presenting to those decision officers. I don't know that.
Okay, I'll sort of come back on it. Sir Keith?
Okay, thank you. Thanks, Colin, Jill and Q, coming along today. There's only who this question relates to, but maybe just an open question. You can all comment if you see fit. What's your thoughts on the public's opinion till one person being disciplined in such a scale of an organisation and such a scale of a mess?
It's a very good question. I think public opinion. If members of the public,
I'm going to sort of just interject a second. public opinion is not just about the civil service, it's about Stormont.
Yeah.
It's that place on the hill. So we all take damage from whoever's actions, we'll just say.
Yeah, I think the public have been concerned by it, and I think, I mean, if it's one of those ones for me where, and I've said this before, you listened for months on end to the feedback coming off that committee, and it was quite dramatic at times. Then you read the report, and you see the recommendations off the back of the report, which for me was a lot, maybe constrained's not the right word, but it was a lot more conservative in terms of any drama that it was creating. So for many people in the public, I think they were looking for the smash ending to the bestseller. That would be a view that people would have expressed to me, external to hear. But then people don't always understand what the processes are that have to be followed. And I think in terms of the freedom that an inquiry has to dig into issues and look at what happened with people, I know a lot of people have been traumatised by that inquiry, and they found it very, very difficult to cope with. So, and I know the public would have a view. Well, it didn't quite end up maybe where they thought it might end up. My view of it is there were different processes at play in terms of the inquiry versus a disciplinary process. Versus what happens in relation to ministers and codes of conduct and all the rest of that. I think there are different mechanisms that have dealt with different constituents, and I'm not in any way second guessing anything that went before. I have a trust in what the disciplinary policy of the civil service is, and I have had to place a level of trust as well, sitting here today, in the officers who were asked to view what was in front of them as decision makers, and the way we do every day of the week in the civil service. We rely on people who sit on selection panels to pick the right people for jobs. We rely on people to sit in disciplinary panels and make the right decisions, and same with grievance panels and so on. So that's the reality of a large organisation that's trying to deal with things in the right way. So I think different outcomes of different parts of this process would be my view, and I think the public would be, well, I think it would be underwhelmed. Might be the term I would use.
So what needs to happen then, Colin, to build that public confidence? Obviously, we're debating the other day about green energy and different forms of energy now. It's obviously all very topical and relevant. The public's going to have very little confidence in any scheme, irrespective of what it is. So how do you build that confidence, irrespective of the process that is carried out, to what the discipline? That's one part of it, but part of it in the future, going forward with any additional schemes, that confidence is gone to a degree.
I don't accept that. I don't think that's correct. And I'll give you a reason why I'm saying that. So I'm talking to you about those days I'm going down the M2 in the evening and I'm listening to the news. I'll also talk to you about the evenings I'm sitting in the house to 2 or 3 o'clock in the morning trying to talk to my colleagues in other departments, and we're trying to stand up services during COVID. So I think people will have a huge amount of respect, huge amount of trust, and a huge amount of confidence in the same civil service that stood up in abundance and really addressed a huge challenge. And a challenge for me was a damn sight greater than RHI presented to it. And there were challenges of project management, commercials, change management, things of having to show agility and react overnight and be accountable for all of that, which we are now being as well, and we're being held to account and everything that was been done during that time. But I know that here, and I know that in terms of the man and the person on the street, people who now talk to me about me working in the civil service, or my friends, or the circle that I know, I think people are taking a different perspective on it. I'm not saying that the lessons of RHI are forgotten or lost. They're not, and we're right on that in terms of trying to work our way through it. But I think that confidence, I think there's a level of restoration of that confidence about how we have absolutely massively stood up to what's happened during COVID, and not only that, for what was done during the time this institution wasn't here. And I think the civil service, I have great pride to work in the civil service. I have great pride in the colleagues I work with. I have phenomenal belief, and I'm coming to talk to you later on about our business plan. When I look back at what was done last year, outstanding leadership was shown. So to colour the entire civil service with everything that came out of the RHI and say, well, let's blacken the whole thing, is wrong. But to take that contrast, I think for me, RHI certainly did, it absolutely pinpointed something. And I think the NIO picked it up perfectly well on that capability and capacity piece. But in terms of being part of something where I have felt nothing but exhilaration and pride of how we've responded particularly over the last 18 months, I think we're in a different place.
May I just interject a quick? I think, Colin, from this committee's perspective, and particularly within your own department, I think we've all seen how LPS has reprocessed itself and sort of done what it has to done, and some various other departments have done. But the question we're still seeing across this assembly, and I can't think of any MLA who here doesn't see that, is that we've got some areas of excellence that we have seen, and we have seen particularly in the health department. We have seen sort of our civil servants performing above and beyond. But we're still seeing really significant areas of, I can say, competency. We're not seeing competency in sort of some of the areas that are quite important to happen. And that was one of the lessons, I think, that came out of the RHI. It's not just a question of sort of misconduct. It was the competency and the ability to do what was, a fairly basic function, is to run a heating scheme. And I think that's one of the big concerns we have, is that I don't think we've been convinced yet that the lesson has been heard, that we need to do something about the competency. We hear, and there is definitely a skill shortage. And I know sort of my learned friend from South Belfast will talk about the fact that we don't have a fast stream programme and we don't have sufficient skill bases coming into the civil service. I mean, those are really significant issues. Sure. But the question one of the big questions to me that came out of the whole RHI process is, where was the competency? It was a basic heating scheme. It wasn't the cutting edge of anything. It was a very basic piece of legislation, and time again we're seeing in the Assembly, regrettably, we're still seeing that process, that this degree of competency is not here. So it's the question of sort of the culture piece to do that as well. Keith, do you want to come back?
No, I'm fine, and appreciate your answer, Colin. Thank you. Thanks, Chair.
Okay, Matthew.
Thank you, Chair. We've broadened this out into a discussion about culture, so away from the disciplinary procedure. So I'm afraid you will have to forgive. We've now had permission implicitly to ask broader cultural questions, but thank you for coming. Obviously, I endorse statements that have been made about the performance of civil servants during the pandemic in terms of creating extremely novel schemes under extraordinary pressure, and it's very welcome and acknowledged. So I want to just ask brief questions in two parts. First of all, the specific disciplinary issues around RHI. Secondly, around the broader cultural questions that were noted to in the Cochrane report and are elaborated on in the NIAO report. So just on the disciplinary proceedings, just for the record, and it's been reported already last year, and the Chair touched on it. But just for the purposes of the record, the external panel which scrutinised the Cochrane report made recommendations of, and we discussed this in closed session, but of 14, yes. 14, of which 2 were extremely senior officials who were referred to the Cabinet Office for further action. The remaining 12 were subject to an internal panel which was comprised of 3 senior permanent secretaries here inside the Northern Ireland Civil Service. That's correct. That's correct. Of those 8, of those 12, there were recommendations made by the and correct me if I've got these numbers wrong, the external panel said to that internal panel of permanent secretaries that there was no case that 8 of them had that proceedings should be continued for 8 of them, but not for 4 of them.
There were 3 that they said, and then 1 left. So they considered. So the internal panel dealt with 8 cases essentially,
the internal
based
panel
on. So the internal panel agreed with the recommendations essentially of the external panel and progressed the 8 cases.
And of the remaining, of the remaining 4, 3 they found there were insufficient evidence to proceed, and 1 that person left the civil service. Do we know if the external panel found what their finding was on that person? I'm not suggesting we pursue that person, but do we know what their finding was?
No, because they left. You know, so
They left before the internal panel was able to
hear their case.
Hear their case, so we just don't know.
Yeah.
Is the case, sorry, just to under the civil service rules, does that mean when you leave the civil service, that's it? All disciplinary and processes stop?
Yes, because essentially the employment contract is broken. You can do, in the case of the Cabinet Office, there was somebody who continued with it on a voluntary basis, but you can't, the employment contract is broken. If, however, you have gone through the process and you've been disciplined, then you can't if you've been disciplined and dismissed, you can't reapply for a job in the civil service.
But not as a civil service, but could you be re-employed as a consultant?
I don't know, is the honest answer. That I doubt it very much. We can look into that.
Yes, please, because obviously one of the issues we have is that some people who have left the civil service who disciplinary proceedings were not followed with are in very senior roles in public life and are on public bodies or potentially in public bodies.
I'm not aware of anybody, because in terms of this RHI case, because as you know, the 2 most senior cases were dealt with by the Cabinet Secretary. So the Cabinet Secretary was the decision officer in those 2 cases, and he determined no case to answer for either of them. So those cases have been progressed.
Matthew.
Thank you. So, and this is largely for the record, but of the 8 cases that the internal panel scrutinised, they found there was it wasn't no case to answer. It was that they were not going to proceed with disciplinary findings, other than in 1 in which the person was given, there was a disciplinary proceeding. The disciplinary proceeding was a written warning.
Yes. So just for the record, of the 12 cases managed by the internal panel, 3 were determined as having no evidence to support the misconduct allegations, and 1 was determined as having insufficient grounds to progress disciplinary action. Of the remaining 8, 4 progressed to disciplinary hearings in June 2020. Of the 4 that had progressed at that time, 1 was given a formal written warning, and in the case of the other 3, the panel found that there was no evidence to support any misconduct. Okay. And then, as we discussed in the closed session, the other cases were dealt with on foot of legal proceedings which had stayed. Yeah. Those processes under the agreed NICS disciplinary policy, and there were 3 of those cases and 1 individual left. Okay. So that accounts for the 12.
Fine. Okay. Thank you. And then, I just want to understand the word, what we mean by misconduct in these cases, because a lot of this, and the Permanent Secretary kind of alluded to it before, is around the overlap between incompetence and misconduct. Sometimes my understanding as ex-civil servant, hopefully I've never in this position myself, hopefully no one ever had to say it about me, incompetence becomes so gross that it becomes misconduct, is roughly speaking how I would have understood it, that generally speaking you can be incompetent, you can be performance managed, you might even be, well, at a certain point your incompetence becomes so bad that it is deemed to be misconduct. Is that, I don't know if you're willing to talk about the 1 case in which a formal written warning was issued, but was it the case that, would it be a fair depiction that person was found, was the misconduct closer to gross incompetence than it was to malign intent?
So in general terms, in terms of dealing with employment matters around disciplinaries, there are all sorts of of issues that need to be looked at in terms of good practice, and that is underpinned by the Labour Relations Agency Code of Practice.
Yeah.
And that very much focuses around the kinds of things that you're talking about, in particular the burden of proof, and also determining whether or not there has been natural justice through a process. So does an individual have the right to put their case, their mitigation, have the right to answer allegations against them? And obviously that process allowed for all of that. In terms of misconduct, it is exactly that. In terms of the kinds of tests that you look at are around intent. Was it willful or not? What were the circumstances, etc. So that's what that disciplinary panel would have listened to, all the evidence around that. So it is not our job as HR professionals to hear the cases, but it is our job to make sure that the process is right. So the decision officers in those cases, and the case that you're talking about, would have listened to all of those things and considered, did they have reasonable belief after reasonable investigation?
Are you able to say that there was that in this particular case that there was a significant degree of intent as opposed to simply gross incompetence, intent towards
No, I mean, I'm not commenting on that particular case because I wasn't privy to all of that. I'm saying there are a number of factors. Intent is one, mitigation is another. All of the context that people are particularly operating in, their seniority, their circumstances, their lack of, so any individual will obviously have the allegations put to them, as is correct, and they then have the ability to explain and put forward any mitigation. I'm not going to comment on the individual case, but a written warning is where the offence is of a serious nature. Gross misconduct is normally where essentially almost the employment contract has been broken.
Yes. So this was not a finding of gross misconduct?
As I said, a written warning is where the offence is of a serious nature.
But you then
so that's the definition in the
But you then said gross misconduct is where the employment contract has been broken, so you are delineating between the two?
Yes, so the outcome for gross misconduct would either be dismissal or a final written warning.
So we can conclude from that this was not a finding of gross misconduct against her. So I just want to briefly, because I want to let others in. The Permanent Secretary was talking about a thing about which I have corresponded with Nick's HR about this subject, which I'm very passionate about, both civil service reform and then also the connected issue of civil service recruitment. The New Decade New Approach says there will be reform, I'm trying to find the exact detail. Of course, we should all have New Decade New Approach open on our devices at all times, and we should be referring to it constantly. I'm sure we all are, and I'm sure everyone in the civil services, but it says there will be further reform of the Northern Ireland Civil Service. When can we expect to hear more about that?
Yeah, I think there's a number of things happening already around that space. In the first thing I would just mention, and Jill can add to this, there is a review of recruitment policy which is ministers initiated already. There's also a further review of the operation of the recruitment service in terms of how you recruit staff, and that's a short-term exercise. Both of those exercises should report within policy one by Christmas. The operational one, where we're trying to short-circuit the length of time it takes us to recruit by the end of the financial year at the latest. And there's a third piece, and the third piece is looking at the operating models that we use for both human resources and finance. And we're very, very clear that the human resource model that we have is not working in any way that can be described as optimal. I think we're working in a way which is slower than we would like, and that affects a number of areas of human resources work. And to take that forward, we have a programme called the Central Government Transformation Programme, and essentially we're trying to replace two large systems with one integrated system, but as part of that we need to re-platform how we do HR.
Okay, I do want to, because I think we have, I check with the clerk, I think we have a specific hearing on this later in the year, and I will be boring you on that then. I think I'm right in saying that we're planning on having a specific session, so I don't want...
Just so you're aware, Matthew, and again for the committees, I've been in conversation with the chair of the executive committee, executive office committee as well, because indeed one of the things we've been trying to work out is who's got specific responsibility between the head of civil service and the TEO, and who does what and what Colm does, and where it all interlinks as well. Yeah. So I think we'll be looking at sort of a joint session to try and achieve that.
If you look at the memorandum of reply that went into the capacity and capability piece, you'll see there's a reference in there where it talks about how the two departments, how the Finance Minister, First Minister, Deputy First Minister and TEO and DOF actually work together on that basis. We are very clear on what the Minister's statutory responsibility is, but also very clear that TEO and the NICS board have an important role in there. So there's a process whereby that's unfolding as we go.
So I want to turn over to others now because I've been hogging time, but like what you said to me, you started with a statement which was very, I think, strong on, yes, both high performance of people, but also the need for pretty fundamental restructuring, and I agree with that. But I would have a concern that those seem to be separate work streams. It doesn't seem to be a programme of civil service reform. Is there a single or connected programme of civil service reform? And if there is, who would be is the SRO you, or is it the new head of NICS, or even the new secretary to the executive?
The civil service reform's massive, and I've yet to see someone who can define for me exactly what civil service reform is, because it means different things to different people. Mm-hmm. Okay. So there are aspects of that where I would have responsibility from an official level. There are also huge aspects as well where Hawks will be responsible for driving that, with the permanent secretaries of the departments as well. So there's a very collaborative piece that has to be worked through.
Yeah, I'll turn it now. I will say, Chair, I think we do need more on this, because I think today's about RHI and I'm already straying into things.
Jill just wants to come back.
I was just going to say, just in terms of maybe some of the things that you're particularly interested in are all contained in the agreed NICS people strategy. Okay. And so that does contain a fundamental review of our recruitment policy, which is as Colm said, is well underway. Doubling our student placements, absolutely looking at significant increase in apprenticeships, and developing our own graduate trainee scheme when we weren't able to carry on with the GB one. So they're all in play. So in that regard, the sort of route into the civil service, and a big community and marketing outreach plan as well that goes with that. Okay, great.
Well, I of course would advocate the Make Change programme to anybody who, and indeed the intellectual property, including the logos, can be made available for no fee whatsoever to the
end of party political broadcast. Yeah, we know it's election season. Jim, over to you. No, Jim Alistair.
I would like some factual information from our witnesses. How many civil servants were identified out of the Cochrane report as having been subject to criticism, either as to their competence or their conduct?
I'll be honest with you, Jim, I haven't sat and counted them up.
Why not?
Well, why would I? With the greatest respect,
well, we spent we spent £13.5 million, if I recall correctly, on a public inquiry. There were many criticisms from Lord Justice Cochrane of civil servants, both as to competence and to conduct. And you, as Permanent Secretary, tell us you don't even know how many civil servants were identified, and you're not interested in that?
Now, what I'm interested in is what the root causes are, and correcting those root causes.
Sorry, you're responsible for civil servants. We have a Lord Justice of Appeal who conducted an inquiry, who made criticisms of a number of civil servants as to their competence and how they conducted themselves. And you come to this committee and display you're disinterested in the number of civil servants so criticised.
What I'm interested in is the number of civil servants who faced disciplinary procedures and what the outcome of those procedures were, and how we take this forward and make the civil service better and stronger and improve it. I'm sure Sir Patrick would want us to improve how the civil service operates and what it does. So that's
I'm sure Sir Patrick would also want you to know and be able to tell this committee how many civil servants he actually criticised if you were taking his report seriously.
Oh, I did take his report seriously. Yeah, I did, absolutely.
Right. Well, let's just look at how seriously it was taken. Because I'm sure those criticisms by the Cochrane report weren't made lightly. You don't know how many civil servants apparently, or want to know, how many were criticised. But of those that were ultimately, and it's a relatively small number, subjected to some sort of disciplinary proceedings, we do know that one, only one, received any sanction. Is that correct?
Well, just so we're clear, and I accept your question, but just so we're clear, the external panel was set up to identify the number of people who needed to face disciplinary action as a consequence of the RHI findings. That is the fact that I'm interested in. I'm interested in the fact that there were senior, well-equipped, well-experienced people chosen both for the external panel and for the internal panel, and it's in that process that we have to trust, because I can't sit here and rerun that process with you, Jim. It's done.
No, I'm not interested in kicking up dust. I'm interested in getting the facts. The facts are that one civil servant received a level of sanction. Yes or no?
Sorry, Jim, I'm just going to come in here as sort of the chair. It's an interesting point you've raised, and I'll let you come back in at the moment. That's a question of disciplinary process. But what other processes were put in place? Because obviously there was a significant number of civil servants were identified as having failed in some way or another during the RHI report. There are people we have heard, and through Jill, you had talked about the process of misconduct and people who met the threshold for misconduct, and that was being dealt with by the external panel. But what about all the others who were deemed to have failed in their processes? It might have been misconduct, but their ability to do their role, to do their job, or whatever it happens to be, surely we must have some indication of those numbers and what processes we've put in place for either retraining them or making sure they're not allowed anywhere near sort of renewable heating schemes or dealing with public finances or those issues as well. So has there been any work done on that? Because, you know, we're concentrating here on the sort of the misconduct piece from RHI, but the piece we haven't heard about is, and I think Jim has raised a very valid point, is misconduct is one thing, but what about sort of the other levels there were? Surely there must be some levels of information out there about the numbers of civil servants who failed, who had been identified as failing by sort of Lord Justice Coughlin's report. And what are we doing about them? And have we had any information about that and any of that process?
Well, given the brief that we were coming with here today, that's not in. I haven't researched that. I haven't gone across that.
Colin, could you take an undertaking to do that and bring that back to the committee?
Yes, absolutely. We'll look at that.
In general terms, there has been considerable work done on, you know, the emerging findings, if you like. At the time, they were particularly around the skills piece. So there has been, you know, new training courses put in place, and obviously we've reviewed the performance management policy, and we have identified a mandatory handover. So where people are moving from one job to another.
Sorry, Jill, could you say that again?
So
you mean you don't? We're just introducing mandatory handovers now? Well,
there's always been handover in terms of best practice, but we didn't explicitly say it was mandatory before.
I'd prefer to pick this up separately because I know there's a lot of work.
There has been a range of work done.
There's been a lot of work we've done, particularly around things like project program management, those key areas, commercials, that sort of stuff that we've also had to do. I'd like to just parcel that up and just bring that back.
Well, maybe there's another point, because I remember earlier on in this time of this committee, we had a discussion about, it was about finance officers and who had actually done the finance officers course, and we realised that quite a few of the senior civil service hadn't actually done the finance officers course, so we're filling finance officers' position, and now we're just introducing mandatory handovers.
I'm happy to come back on it and explain it in a bit.
No,
more.
I think it's about bearing in mind sort of the comments we've already made about,
Yeah.
you know, there's areas that we've seen of the civil service are showing excellence through the COVID thing, but as
Yeah.
you know, as MLAs, we see day in, day out coming through this assembly, areas where, you know, a lot of the lessons identified, I don't think they'd necessarily be learned in some areas of RHI are still there. But sorry, Jim, keep going. Jim.
What is the lowest sanction that can be imposed under the disciplinary code of the civil service?
Informal warning? Informal warning, Jim, is the lowest. An informal warning.
And then above that, written warning,
There'll be a verbal warning.
and then written warning,
I believe so, yeah.
Formal warning.
Yeah.
and that's the highest level we got in terms of discipline, and that restricted to one civil servant after all that Lord Justice Coughlin had to say. Is that correct?
That's what the facts say, Jim, yeah, in terms of the numbers, yeah.
What does that say then about the civil service acceptance of Lord Justice Coughlin's findings? If he was critical of, in your case, an unspecified number of civil servants for their competence and conduct, and the outcome of that is one written warning to one civil servant, does that put us in a situation from the public perception that the civil service effectively doesn't accept the criticisms by Lord Justice Coughlin?
No, I think the civil service is on record as accepting those findings absolutely, and has been acting to try its very best, use its best endeavours to improve how it functions and how it operates.
Not much reflection in the disciplinary outcome, though, is it?
Well, I think the disciplinary process is a disciplinary process. It has its own protocols. People bring forward their case to be heard. They bring forward any mitigations they have. I don't know, Jim. I wasn't in the room whenever the senior officers were reviewing those cases. But if you're asking me, do I have faith in those senior officers in terms of what they were doing? Yes, I do. Do I have faith?
You don't find it very striking in terms of contrast between the multiple criticisms of Lord Justice Coughlin of civil servants and the eventual outcome of one written warning?
Well, I think Justice Coughlin's role was a very different role, and what he was trying to do was in a different approach. A public inquiry is a very different thing than a disciplinary outcome or a disciplinary process regarding someone's contract of employment.
Let me ask you something else. Civil servants identified by Lord Justice Coughlin in terms of failings in their competence and their conduct. How many of them, since they appeared in front of the inquiry, have been promoted?
Again, it has never been my concern to follow that up and view that.
Sorry, Jim, just to think, I think, again, sort of Colin, sort of after when you report back to us on the numbers who weren't for misconduct but who were dealt with in other forms of administration process as well, would that be useful if we can see if any ones who were specifically mentioned in Lord Coughlin's report have been indeed promoted, and in what areas? I think that would be a useful thing for the committee to know.
Well, I'm just checking the legals on that. Legally?
Well, we can take it away and have a look at it. I mean,
You don't have to give us the names. You can say that for the people within it. You can report on how many have actually, if there were X number at certain grades, are they still in those grades? Have any been demoted? Has anybody been demoted? Sorry, it's Jill.
Demotion would be one of the things that you could only do that if there was a substantive reason for demotion. That would be linked to the disciplinary process.
So I think the answer is no. No demotions, one written warning, and no knowledge not only of how many people were criticised by Lord Justice Coughlin, but no knowledge of how many of those have been since promoted. Are we real in terms of trying to rebuild confidence after the RHI fiasco?
We're very real, Jim. We're very real. And I gave my answer to the other member a wee while ago, that civil service cannot be defined by what happened in RHI. The civil service has...
Yes, I know.
No, it can't.
I appreciate that. But, you know, we are dealing with the most singular spotlight that there probably has ever been on the civil service. And you, as Permanent Secretary, come to this committee and tell us you don't know how many civil servants are actually criticised by Lord Justice Coughlin. All you can tell us is one got a written warning, and you can't tell us how many were promoted since, even though they were criticised. And I'm making the comment to you that I think that is a reflection of just how casually the civil service seems to have taken the Coughlin report.
Well, Jim, if you knew me at all, you'll know I don't take things casually. And I've been very, very well prepared to come here today to talk about the things we need to talk about, and as much as I can.
Well, I would suggest being well prepared.
Jim, through the chair.
We used to be able to tell us how many were mentioned and how many have since been promoted.
Well,
I would regard that as being well prepared.
Jim, through the chair. Yeah, I think the point has been. I think the point has both been made by Jim and Colm, and we'll move on to the next questioner, and that is. Sorry, Jim.
I did want to ask one other thing, if I might.
You can. I'll let you. If we've got time, I'll let. Sorry, Jim. If we've got time, I'll let you in at the end. Alicia.
Margaret, Chair, and thank you for your evidence to date as well too. And much of what you had actually covered, Jill, we have it in our papers and that as well. And I think that it's incumbent on everyone to make sure they sit down to read the papers, and that it would maybe save us quite a bit of time when we do come to these inquiries and so on. Just in relation to a comment that you had made, and it's in the same way, similar to what Mr. Buchanan was commenting on as well too, that where really it's implying that was a systematic failure within, we'll say, the civil service itself in relation to RHI and so on, as opposed to individuals taking on board responsibility, or anyone identifying responsibility with an individual. It's a bit like someone blaming the app as opposed to maybe the designer of it, in a sense, that the app failed, but you don't blame the guy that actually maybe constructed it and so on. And whenever it's that kind of systematic type failure, we say if that's used as the reason for many of the problems, it's quite easy then, as I say, for the general public and that as well too, to sort of arrive at that conclusion. You know, they're not actually pointing the finger at any individual, or they're not allocating responsibility as well as blame to individuals as such. So therefore, it's a bit of a cover-up, saying it's a systematic failure. And in addition to that, then, whenever we find that we get a legal opinion that actually is closing down information coming into the public domain and so on, that in itself again too is sending out what I believe is the wrong message. And I agree with you entirely that in many respects that the civil service has been admirable in the way that they have dealt with the whole COVID crisis and the likes of that. And I don't think that their reputation just hinges on RHI in itself, but it is tarnished as a result of RHI in many respects, as is that of MLAs. Because in many respects, people see us nearly as being the people who were responsible for it, and that we are here in Stormont and we should be scrutinising through our committees and so on these things. So I come back to that question again too, that given the current position, say, and I had made that suggestion earlier on, that we should get another legal advice, external, on some of these issues, that all of us are in danger of falling into disrepute and being part and parcel of a cover-up as far as RHI is concerned.
Well, just in terms of RHI, the question of RHI being a cover-up, we work to a very high standard in terms of ethics. We know there were mistakes made in RHI. We know there were mistakes were made. the report clearly sets all of that out. But when you use the term cover-up, and where I've been really focused on this has been the disciplinary process coming here today. So I've been fascinated by the disciplinary process because I came into the outside into this after it had happened. So I was interested in the dynamic of set up an external panel and what were the calibre of people like on that external panel, and that they were entrusted to review all of the mentions of all of the individuals who were referred to in the findings by Sir Patrick. And they were tasked with making that judgment about how many of those people should face the disciplinary process. And so I'm interested in that group. And then when I see that group coming forward, you sort of say to yourself, well, okay, we've got very highly qualified professional people from very senior levels. I think from memory, from not just our own jurisdiction, from outside our jurisdiction. What interest would they have in covering anything up here? None. I'm looking at an internal panel of 3 permanent secretaries of the highest integrity. Sue Gray, ex of the Cabinet Office, now back in GB. And her role, if I recall correctly, was in and around all of the stuff to do with ethics in the Cabinet Office. Mm-hmm. What would possess Sue Gray to be involved in some kind of cover-up around RHI? So in those groupings, I place my faith that A, the external panel have harvested from the findings of the RHI report those people that should be facing, or in their view should be facing, a potential disciplinary process. And then have faith in those other people then who will make those decisions about whether disciplinary action is required or not. So I've been a civil servant since 2005. I've done human resources jobs for many years as part of my professional background. I haven't done them in a long time, but I've had a lot of experience of doing it. And I know by sitting on panels and I'm looking at very senior officers how they prepare for this, the evidence they weigh up, the mitigations they take on board as well, from people coming forward with, well, why did certain things happen? Why did you perform in a particular way, or behave, more importantly, in a particular way, in respect of something? So for me, I have faith in that. I have faith that the civil service selected the correct people to sit on those panels, and the judgments were fine. And on that basis, I would never accept that there's a cover-up. I would accept that there are differences in terms of what Sir Patrick can say and do and find versus what will come out of a disciplinary process. And that's the point I'm really trying to get across today.
And obviously 2 of those cases were also heard by the Cabinet Secretary. So their decision, you know...
I'm not suggesting...
No, you're not. I know you're not.
Yep. And like yourself, I know the name of Sue Gray, and I would have met Sue Gray personally, and I would have had the highest respect for all of the work that she does and continues to do, I'm sure, and England now again too. The general public in that probably maybe don't know Sue Gray. I don't know anything about Sue Gray.
No, they don't.
So therefore, it is a case of perception in terms of the general public in that as well. So we do have a responsibility, and I get back to my conclusion in a sense, and that I do feel too that the way one regains that confidence is by total and absolute transparency. Because whether or not the system can accommodate, we'll say, in dealing with those people who have been referred, we'll say, to disciplinary matters and all the rest of it, and only one of them ends up, we'll say, in a sense, incurring a warning as such, right? That's one thing. But for the general public then to look at that then at the same time and to be given that impression that some of the information may be kept from them because of injunctions or anything else like it, at least a question mark that sort of sullies all of us in many respects. So I would ask you, would you be of that opinion too, that it should be complete and absolute transparency that one is aspiring to in every aspect, even of this conversation?
Well, I said at the very start today that our Minister's default position was to provide whatever information was asked, and that is his default position. And I share that aim always to be open. But we have advice, legal advice, that says that we cannot do that. And if you're asking that we look again at that legal advice, if the committee wishes to write to the department to ask us to look again at that, that's fine. We can do that.
Well, I would appreciate if our committee would decide on that and make that recommendation.
Can I beg your pardon, Chair?
Right, Jim.
Could I just add a little bit of legal to that? So it's not that the Minister isn't trying to assist. The Minister is trying to assist and be as transparent as possible, but the Minister, like the rest of us, operate under legal constraints. Some of the legal constraints in relation to this very specific bit about discipline is that there's an employment contract with each individual, and that the details of the employment contract and the disciplinary process in the employment contract are to be kept confidential. So that's a constraint on the Minister and the Department. It's not the legal opinion imposing that, it's the fact that those contractual relationships exist as normal.
Maybe,
And
sir,
the
maybe just
Minister has
to interject here, Hugh, and just for Militia as well, just to interject a bit of it. I think, Colm, you talked about earlier on, there was a findings list that was made of the names that came from the RHI report that went to the external panel to decide what.
They'll have taken the names from. They'll have reviewed the findings themselves. Yeah. So
that list of names exists somewhere.
Must do. Yeah.
Okay, and from that we could probably extract, who's been promoted, who's left the service, and what other actions have been taken or whatever particular do as well. Now, with not having to, and obviously taking sort of what Hugh's view of it as well, there's no reason why that couldn't be provided to us confidentially, just so that we could review where those have gone. So that information we could have on the committee, but we would agree to hold that confidentially in much the same way we've had previous confidential issues with the department dealt with as well. I think that would answer Militia's question, and indeed would probably answer sort of Jim Allister's question as well. So we could actually get an overview of what has happened to all the people who were involved in that system as well. And I can't think of any reason under the grounds of sort of confidentiality if we used before. I can't see any reason why the department wouldn't be happy with that. You happy with that, Militia?
I would be happy with an external legal opinion.
Yeah. Okay. Okay. Happy. Jim? Other Jim?
Anonymised.
Mr. Boyle, a company due to the lack of attention to detail or the incompetence of its staff collapses for 3 years. It ceases trading and it isn't resurrected for 3 years. Do you think the staff responsible for that one of them would have got a warning and that would be that?
I'm sorry. I missed the start of your comment there.
A company collapses as a result of the incompetence of its staff. It ceases trading for 3 years. It eventually sort of dusts itself down and gets back on its feet. Do you think that the only action taken against the employees would be one of them to get a warning?
Sorry, what company are you talking about? I don't understand your point.
Well, obviously you don't understand, Mr. Boyle, because you don't want to.
No, I genuinely don't understand your point.
Yeah.
I genuinely don't understand it.
Well, then clearly you haven't been following the line. What I'm saying to you is this institution collapsed as a direct result of the incompetence of staff dealing with RHI. RHI brought this whole institution into total disrepute. It collapsed and was suspended from activities for 3 years. If that happened in the private sector, would the only punishment meted out to the people responsible would be one warning?
I think the judge came up with something different than that. Responsibility for what went wrong lay not just with one individual or group, but with a broad range of persons and organisations involved.
Yes.
Not just a civil service.
But do you think that if a major component of a company, where that happened, you would have one written warning?
I think that's a failed analogy, with respect.
Well, I think a lot of the public will take a different view, Mr. Boyle. Now, could I ask, what on earth does one need to do to get sacked from the civil servants in Northern Ireland? Because that's what many people listening to this hearing today must be asking themselves. At what level do you need to be totally incompetent before you're actually removed permanently from your post? What is the threshold for being sacked from the civil service and all that?
Well, we're talking, as my colleagues mentioned earlier, and I'll draw her in if she wants to come in on this point as well, as you're talking about proven gross misconduct.
And all of RHI, no one was charged or deemed to have been responsible for gross misconduct. No one. In all of that calamitous situation, which brought this institution and brought public confidence in the civil servants to its knees, no one was guilty of gross misconduct. Is that what you're saying?
Well, it's not what I'm saying. It's what the disciplinary process yielded.
Yeah, the disciplinary process, which clearly has such a high hurdle, which has to be passed before someone is sacked, that it's almost impossible for anybody in the civil service to reach it. Isn't that the truth?
No, I think I think we have a disciplinary process which reflects similar to disciplinary procedures and processes that exist elsewhere in these islands.
Well, that's interesting. Have you come across the concept, if it happened on my watch? Have you ever heard that phrase used, it happened on my watch?
Yeah, I have, yeah.
What do you take from that phrase?
I'm assuming the origins of it come from some sort of naval connotation.
Yes, the staff are totally incompetent, but senior officers take the hit, disciplined and are court-martialled, not because they themselves were directly responsible for the decision that brought the ship to hit the iceberg or whatever, but because it happened on their watch and they had overall responsibility for their competence. Is there any concept of it happened in my watch in the civil service?
I'm not sure. What I would say though, it's not a phrase I've heard mentioned very often in the civil service. But what I would say is this: whenever leaders have had to stand up in the civil service over particularly the last 2 or 3 years, they've stood up and they've led from the front, and they've taken us through, I think, very, very difficult circumstances.
And we're not going to be led into the trap of criticising those civil servants in either way, because I think we'd all agree with you. But the point was, not one senior civil servant during the whole RHI debacle fell on his sword, not because he was directly implicated, but because people that he had responsibility for, or she of course, had responsibility for, had been utterly incompetent. Surely heads should have rolled on that basis alone, rather than deliberately pinpointing any fault in the senior officers. It happened in their watch, it should have gone.
Well, again, I would trust a disciplinary process to yield the outcomes that it needs to yield. And I mentioned earlier, in terms of the questions that have come thus far, we have a solid disciplinary process which reflects good practice elsewhere. We've had good people on those panels. What more can be done in terms of assessing people's misdemeanours in respect of misconduct?
It is a disciplinary process that many out there will believe the ultimate punish was a slap over the wrist with a wet lettuce leaf. And that is the honest view of people watching this at home, thinking a standard which would never be tolerated in private industry or many other organisations is tolerated in the civil service. And heads should have rolled for no other reason but as to show an example of just how serious this issue was and how it never be tolerated again. And that didn't happen. And and if it transpires, and I think Mr. Alistair asked a very pertinent question, if it transpires and you would provide us with information, then not only was there not adequate disciplinary action taken against those responsible, but also that some of them have been promoted, well, that will be the ultimate insult if that has happened. And we are waiting for that information with great interest.
Okay, thank you very much indeed, Jim. So the concept of accountability and responsibility, I think any of us who have served in the military have a different view of it, and I do tend to understand what this means by, the captain has the ship. I've been in that situation and I know what it is like to carry the can, and you do it for the entire team. But I take your point, Jim, and that's a very clear issue. Jim Alistair, just a very quick one please, and then we'll have to sort of bring it.
Yeah, well, just on that same theme, Mr. Boyle acknowledged that Sir Patrick found systemic failure across the civil service in terms of management, etc. And yet, his evidence to us today is that those who headed the civil service, permanent secretaries, when one permanent secretary and one head of the civil service was sought to be made amenable, they were vindicated. So again, how can you say that lessons are being learned over systemic failures in the civil service if those on whose watch it happened are indeed walk away untouched, pensions intact, as if nothing adverse had happened? Where's the credibility in it?
Yeah, well, it's an interesting point you make, and I understand the point you make. But in terms of people going through a disciplinary process, particularly a disciplinary process that does not even involve people from here who are sufficiently senior and have a broad perspective and a capability to decide on what merits disciplinary action and what doesn't, I do not believe I am in a position to sit and second guess a panel in that scenario. So the discipline.
You don't think the public might think that it's the civil service looking after their own?
Well, I don't know why civil servants, for example, in Cabinet Office would feel particularly compelled to look after civil servants here, or whether external people with absolutely no axe to grind on an external panel would feel any particular loyalty either. So there
was there an external panel for the permanent secretaries?
No, there was an external panel for the other 12.
You see, we're in the ultimate irony here, where RHI happened, cost tens of millions of pounds, politicians away in the smoke, civil servants away in the smoke, and the hapless individuals who are now to be made the scapegoats are a few farmers who follow the advice of the Minister in the Economy and of their banks and availed of a system, and now they're going to be the scapegoats in this. There's something reeking about that.
Okay, thanks. Just one final one. It's a technical one. And Jim, can you just stay on the line here? Obviously, one of the things that we wanted to see was sort of the roles of special advisors. And special advisors are deemed to be civil servants. Now, obviously, one of the things from RHI is the people who are in the roles of special advisors and how they were being dealt with. Of course, one of the questions we've been asking about, one of the things that came out of RHI was, and indeed sort of the bills that Jim has been involved with and other bills, have been the role of special advisors as temporary civil servants and how they would come under sort of the disciplinary process. Would they be subject, if the circumstances, if we actually had the RHI recommendations all the way through, and I think this is one of the things that we hoped would happen with special advisors, would they be subject to gross misconduct proceedings as well from an external panel, or is that still within the realms of a minister?
It's within the realms of a minister.
So even though that they're being deemed as temporary civil servants, they can't be charged with misconduct or anything else?
Well, my understanding is that their performance, that all aspects of their performance and conduct is managed by the minister. Is that correct? Sure.
Yeah, there was a bit of legislation about that recently, but it's forgive me, Chair, sorry, there was a bit of legislation about that recently, but it is the case that if the person is a civil servant, if there's a misconduct, then there can be disciplinary proceedings taken, but in this instance led by the minister, not, for example, by the line manager in the civil service.
Okay. Jim?
Well, I think perhaps some people should revisit the function of government miscellaneous provisions act, just to remind themselves that SPADs are now subject to the Civil Service Code and disciplinary processes.
Yep. Okay. Okay, everybody. Thank you very much indeed. And I think this has been a particularly important evidence session because whereas I think there is nobody in Northern Ireland doesn't accept the fact that many in the civil service have really come to the fore during COVID, particularly those in the health department, indeed those within the Department of Finance as well, for people to be able to do particular roles and how they've done that. But however, RHI was something that fundamentally undermined people's confidence in this building, but not just in the political system, but also in the entire system across the civil service and everything. And I don't think, quite honestly, we can go out of here thinking that people don't really consider RHI is gone. Because I can tell you this, as a politician knocking on the doors, I'm still getting it day in, day out about RHI and incompetence and how it is and what we're doing about it and why we've got to this stage and it's still there. And there are many people out there who've got real concerns. And I think the concerns that we have from this committee, and indeed from many of the elected representatives, is there has to be accountability and there has to be responsibility. And regrettably, we're not seeing this, and we would like to see that evidence that we've requested as swiftly as possible, please, in front of the committee. But thank you very much indeed. I'm sorry this is the first time you came in front of the committee and we're having a particularly about RHI. But I think looking at sort of the timelines we have today, we were due to have some evidence of you later on about sort of the business plan. I think we'll, with the committee's acceptance, we'll postpone that to a later date, and we'll be in contact with you and the rest of the team to do that as well. But thank you. Thank you, Hugh. Thank you, Jill. Thank you, Colin. Thank you very much indeed.
Any further? Do you also want to write to the department about the RHI action plan?
Yeah, that's it. I wanted to do that as well. Look, team, thank you very much indeed for that, and thank you very much indeed for the forbearance as we worked our way through that. I think fairly early on, we all came to the conclusion that there was no reason whatsoever to have this in closed session, and thank you for sort of agreeing to open up to the session as well. The Minister, during question time, indicated that an action plan in RHI has not yet been agreed by the Executive.
Chairman, just before we go to that, you're absolutely right. There was absolutely no need for anything to be done in secrecy. There was a series of questions made by various members, some very searching questions from all sides there, about, for instance, had anybody been promoted?
Yes.
I take it that have we agreed to write to the department and ask them for
I'm just coming to that.
Good stuff.
I'm just coming to that, yeah. So the first one was about the question time the Minister said about an action plan in RHI has not yet been agreed by the Executive, but he hopes it will be the action plan shortly. I think we should write to the Minister and ask what's happened to that action plan and bear of the evidence we've heard today and ask him for a fairly swift response. The second one, I think, on combination of, Militia, you wanted to see the legal advice?
Yeah.
Yep. So we need to write and say we want to see that legal advice.
Is the committee also suggesting that the department reconsiders its legal advice in order to disclose further information in respect of the RHI disciplinary process?
That's just what I was about to say.
Well, actually, I even went a stage further. It's not legal advice from within the department itself. That it should be an alternative opinion, or
Reconsider.
Right,
An alternative
reconsider.
opinion. Okay.
And the third piece was we asked the question specifically of Colin and he agreed to it, was that because there is, and I think, allow me to check the expression, there was a findings list that included the names of the people that raised within the RHI report that went to the external panel. From those, they decided which ones would be taken forward for disciplinary process. But obviously, we want to know what's happened to the other ones, whether they've left the civil service, whether they've been promoted, or indeed, if any of the recommendations from that, they've been retrained.
Jim wants to come in.
Jim, go ahead. Or is it Jim or Jim?
Jim Alistair.
I was just going to revert to the question of the legal advice. I think the committee should always remember that the privilege that attaches to any legal advice doesn't rest in the lawyer. It rests in the person who sought it. So in this case, in the Minister. So the Minister has the capacity to waive the privilege and to supply it.
Thank you, Jim.
Right to Minister
Excellent.
then
Right
in
to
that
the
regard.
Minister.
In that regard.
Excellent.
You
Good.
That was free.
It's good having a barrister in your committee, isn't it? Right, are there any other actions we want, team, from this?
Good job you're not paying them.
I think, Chairperson, did members also refer to, they were looking for a breakdown of the levels of misconduct charges that were considered?
Yes.
And they'd also asked a question about, can dismissed employees be re-employed as consultants?
Yes.
Or for those who evaded proceedings by leaving the civil service, can they simply be rehired at some future point?
I think we should be on. That's a question we need to ask.
And then you're also asking about the numbers of staff members that have been retrained, and also seeking clarity around mandatory handover and whether financial officers have been trained.
Yes, I think that surprised me, committee, that we're only now looking to mandating sort of formal handovers. I thought that was quite strange.
I thought it was in their procedures, so
Okay.
I must be wrong.
Just for clarity, see the external panel you referred to, or they referred to, that 14 number, was there more of a number went to that panel and then 14 selected from it to go to the other, or was it 14 till it and then reduced down?
I think every name that went, again, this is, we need to see clarity in this, but it should have been every name that was raised.
Went to them and then what they did with them numbers.
Yeah.
14, yeah.
Could I just, on the promotions, not just the number of promotions, I'd like to know, without naming anybody,
Grades.
Mr. Smith go from, what did he go to or what did she? Because there could be a really interesting can of worms here. If someone has progressed quite rapidly since RHI, even though it's quite clear they were incompetent during that process. So I think, this one will run and run. And I think that their reticence to speak about that trade, we know of one obvious one, of course, but what happened to all the rest? I mean, have they been forced to languish as a result of their incompetence, or have they been sort of bouncing up the line like everybody else?
But the answer is they were not subject to any other disciplinary. The only disciplinary was a written warning. So one of the other things you could be disciplined with is you can't be promoted, but I think the evidence is no, that didn't happen.
But were the
They didn't
people who were
languish.
investigated, have they sort of flown up the ladder, as it were?
They certainly haven't languished. Well,
That's
as a
what I want
consequence
to
of-
know.
Yes, indeed.
In fact, could it be that you did better in your promotion as a result of being under investigation by RHI than if you hadn't been involved at all?
Does it take an entirely new term to the idea of competency-based interviewing?
Thank you, Chair.
On that point, I will move to the next agenda item. Team will reschedule the oral briefing for the Department of Finance Business Plans 21-22. We then move into the next section, which is Chairperson's Business, item number 6. First item 6.1, reserving contracts for the voluntary and community sector. The Minister indicated during finance questions on Monday that he is to bring forward a further revision to procurement policy, which would require departments to engage more with community service providers to establish whether grant funding is a more appropriate mechanism. The policy note is also to provide guidance on reserving contracts for the voluntary and community sector and highlights the provisions in the existing procurement legislation to create markets solely for third sector bodies. Are we content to write to the Department to seek clarity on the proposed changements to the procurement policy? Are we agreed? Agreed. There's an informal meeting with the House of Lords Committee. The committee previously agreed that I should meet informally with the House of Lords Committee on the Northern Ireland Protocol when they visit Northern Ireland. This has been scheduled for Monday the 8th of November. Are we content? Agreed. Yep. Extra item on Chairperson's Business. I attended the Chairperson's Liaisons Group this meeting, or this week. As part and parcel of it, it's obviously, I think there's close on sort of 40 pieces of legislation working their way through the system. The opportunities for additional sessions, I think, are, bearing in mind the fact that most of us are now sitting on more than 2 committees, are very limited, and also is the issue of the staff. It's the difficulty of getting extra staff as well. It's just to highlight the fact that there is a considerable amount of pressure in the system. But obviously the most significant thing for us is obviously we've got the budget process to deal with. And again, one of the things we might consider, and I might ask the committee, I think we might write to the Minister to ask him what positions he's going to put in place just in case the legislation goes through, the continuity of the Assembly legislation goes through, so we don't have an executive in place, but we do have ministers in place, and how that's going to potentially affect the budgetary process. Because again, sort of the timings of that, if we're agreed to that, I think it's useful if we had that. I think that would be a prudent piece of looking ahead.
Agreed.
Agreed. Okay.
Committee number 4, the apologies and the declarations of interest.
Oh, sorry. Do we have any apologies during this meeting? Yes, we have. I had those. And any declarations of interest? Sorry.
No.
Moving on to item number 7, draft minutes of the proceedings. Draft minutes of the Finance Committee. Sorry, Keith, I should be letting you do that one,
I think
since I wasn't here for it.
You carry on.
Yeah. Are we agreed that they're an accurate record of proceedings? Agreed.
Yes, that's the fact.
No matters arising? Agreed. Correspondence. Members asked to note 8 items to receive correspondence from page 185. Statistical data. Members are asked to note at page 187 a response to committee queries regarding the provision of statistical data. The Department appears to be indicating that statistical data will continue to be provided by the UK to the EU, and this appears to be a provision of the withdrawal agreement. Is the committee content to note?
Note.
Noted.
Well, Chair, I would like to note and comment.
Yes, please. Go ahead.
It underscores the oppressiveness of Section 7A of the Withdrawal Act, which uniquely leaves Northern Ireland subject to all these EU laws that we don't make and can't change. And here's an example of one of them.
Just as a matter of note, I've previously been in discussion with the chair of the Fiscal Commission, Independent Fiscal Commission, and there was a discussion about sort of data, and one of the issues is the fact that the sort of our data isn't compatible with the EU data, and there is an issue to do with it as well. Would it be worthwhile the committee writing to the department and asking if there's an issue of compatibility of data, never mind whether it's it's a considerable burden or not? Because I do understand that one of the issues is going to be going forward is that the 2 sets of data don't marry up. Contented? Good. Moving on to the next item, Peace Plus funding. Members are asked to note ministerial correspondence on page 189 on Peace Plus funding of around 1 billion over the years 21-27. The Minister indicated that the consent of the North-South Ministerial Council is required. It is indicated that delays to this process will have an adverse effect on the recipient organisations. I think we probably need to write to the Minister and ask for clarity on that, because I am not, when the executive wasn't sitting for 3 years, the process of allocation of Peace Plus money continued. Sorry, go ahead, Keith.
Yeah, I think you responded to the question that in the chamber. I think you did, and you referred to that was agreed prior to the 3 years. From memory, this was the response to the question. But it's going forward, I think, is the issue. But I think in the
no, let's just get some clarity. I wouldn't mind some clarity.
I think that it was discussed already in the chamber.
Sorry.
The clarity is there, that it does need the endorsement of the cross-border body, essentially. Other than that, that money is at risk, and that issue has been raised in the chamber and that as well too. And the Minister has been very forthright and endorsed that position as well.
Thought?
Yeah, I was just going to say, I was listening to the Minister's response, so it is slightly different in the fact that it continued for 3 years when the fund was already set up. In this instance, I think he said, and I don't want to be misquoting him, that it has to be endorsed by the various institutions, including the North-South and the Assembly, before it can take shape, and that is what is in danger.
Okay. Gemma?
Yeah, sorry, thanks, Chair. No, I just want to echo the words of Philip and Militia there, and just express the concerns that many community groups in my constituency would be facing if they didn't get this money. This money is a lifeline to an awful lot of community groups, and particularly in the border areas. So I would really like some clarity on this, and I really hope that the vote isn't right, because community groups would just fall to the wire if this money wasn't there.
Okay, Matthew.
I think it's worth saying, I don't know what the specific arrangements are, but just to be absolutely clear, what the Belfast agreement says in Strand 2, it does make explicit that one of the key areas of North-South cooperation is in relation to the EU and the disbursement of EU funds. That is written into the original agreement. I know certain people on this committee don't like that. Indeed, the annex, which sets out areas for North-South cooperation, says may include the following. And then number 8, relevant EU programmes such as SPPR, Interreg, Leader 2 and their successors, of which The peace project, peace funding is one. I think it's really important to point out that EU funding has always been core to the operation of the North-South Ministerial Council and Strand 2 of the Good Friday Agreement, despite what is sometimes asserted by people.
This is a matter of clarity. So, under Withdrawal Act, because obviously we're not in the EU anymore, under the Withdrawal Act is the monies that comes from the UK side. I think that's the 860 million or whatever has been provided from the UK side. Is that, again, this is one of the questions I think needs to be asked, bearing in mind that sort of we're not in the EU anymore, the Withdrawal Act is in place. What are the implications of that? Because I think when the Minister said what he, and I have no doubt the Minister was quoting indeed from the Belfast Agreement about the North-South Ministerial Council, but it might be interesting to find out if it's been amended in any way by the Withdrawal Act, or indeed if they've remembered to put that particular part of the Withdrawal Act into it.
Well, I mean, the point here is that obviously the text of the Good Friday Agreement is not statute. That's, do you mean? I don't know whether the Northern, it's the Northern Ireland Act.
That's the point. It's not. Yeah.
But I mean, the point I was simply making was less the legal point and more the broader political point that the text of the GFA is explicit that that's what the NSN, one of the NSNC's core functions. I'm not. It's not my job to explain the Minister's statements. He can do that himself. But I just think it's very important to reiterate that disbursement of EU funds is a core function of Strand 2 and the NSNC.
Okay. Are we just content to note?
Sorry.
Yeah, in terms of noting, I mean, I think we should put in record our dissatisfaction that £1 billion is put in jeopardy because of the DUP's potential non-attendance. I mean, we're kind of in a situation where, I mean, there was promised money through the Shared Prosperity Fund that, you know, we have no certainty, and now we have this other added issue of £1 billion, as Gemma has quite rightly identified, will have a very, very serious impact on communities, groups and organisations right across the north because of non-attendance at NSC council meetings, and I know, so I think we should be expressing our dissatisfaction that is the case.
Just say, Chair, and if I can say once again too, it already has been confirmed that it requires sign-off at the North-South ministerial level.
I'm just asking the committee to note.
Yeah. So, that,
so are we agreed to note?
Yeah.
Agreed. Right. Move on to the next item on the agenda, Shared Prosperity Fund and Community Renewal Fund. Members are asked to note at page 191 a copy of a letter from the Executive Office Committee to the Minister seeking information on the Shared Prosperity Fund and Community Renewal Fund. Are we content to note?
Read my mind.
We are still here. Good. Next item on 9.5, Barnett Consequentials. Members are asked to note at page 192 a response from the Department confirming that the expected Barnett Consequential associated national insurance increase will have to be spent on health and social care, but the associated eligibility rules for social care provision will be for the Executive to determine. The Minister appeared to indicate during question time on Monday that the national insurance consequential might be around 300 million as opposed to 400 million as previously reported. No information is given on unhypothecated allocations to the Executive associated with health allocations in England. However, during question time, the Minister indicated that this would be around about 180 million, which would be allocated on October monitoring. I just want to get some clarification from the Minister from this, because the statement from the Treasury and indeed from the Secretary of State, I think it was 400 million, was coming to us as part of the national insurance, the new national insurance contribution for health, or however it's going to be future named, and that would be 400 million. I can't quite understand how we got from 400 million to 300 million, and I'd just like some clarity from the Minister of how that's been worked out. Jim?
I have to declare the ultimate interest here because I'm paying £42,000 a year in care home fees. That's in the public domain. In the rest of the UK, or at least in England and Wales, this has been hypothecated to enable those who are paying care home fees not to pay beyond £86,000 in total during their lifetime. Now, I understand that the Prime Minister who made the decision is doing that in England and Wales, but the money is simply under Barnett been given to us in Scotland, and the Minister can do whatever he or she feels is required. Undoubtedly, what I think is going to happen here, it's going to be used to meet the huge shortfall within, for instance, A&Es and the COVID recovery programme. The only thing I'd say, and I'm not saying this on my own behalf, but on behalf of some constituents, that means they pay the levy and don't get the benefit. The levy was particularly to prevent people in care having to sell their homes in order to pay for care. So therefore, I would like in the letter to ask what the minister, how the minister's minded, be it 300 million or 400 million, how he's minded to spend it. I think I'm not going to like the answer, but there are many thousands of people out there who are, unlike myself, unfortunately I'm working, I'll pay it, but there's others, and they're facing financial ruin over this, and I think they do require to at least ask the question, is there any hope, which I doubt.
Okay. Sir Matthew.
Sorry, can I just ask you, the 300 million you referred to, I can't find that. Where
No, I mentioned it in, the Minister mentioned it in questions on...
Right, okay.
Yeah. And it was, because the 400 million had already been reported.
Yeah, that's in the... Yeah.
The Minister said no, it was 300 million. And he said, and he made some statement about the addition, the monies because of it was due down to vaccination, but had been reported by the Treasury that it was, the Barnett consequential as part of the national insurance contribution change would be 400 million. So I couldn't work out how we got from 400 million to 300 million, and there was an element that was due to vaccination. I've no doubt the Minister is correct, but I think we as a committee should be asking the question of the difference between how we've got to the difference of that 100 million.
His correspondence of the 20... his correspondence of the 20th of September, did he say the 300 million in the
No, he said this week.
This week, okay.
Question time this week.
His correspondence of the 20th doesn't mention any...
No, it doesn't.
No, it doesn't. That's why we're asking the question. It came as a bit of a surprise. Okay. Are we content to write? Agreed. Moving on to 9.6, hypothecated and unhypothecated spending. Members are also asked to note at page 196 a response from the Department providing a link to a Treasury spreadsheet which shows hypothecated and unhypothecated spending by the Executive over several years. The spreadsheet has been emailed to members. Are we content to note? Noted.
So I was going to make lots. I was going to make the comment that I think this might be something that the Fiscal Council could look at some point, and it might be something we refer to them.
Okay. It's a public domain document.
I'm aware of that, but I mean the broader issue. I can see that it's
yeah, well, it's very interesting. There's all sorts of stuff in it.
Should we? Is there a recommendation there that we forward it on to the Fiscal Council, just in case that they haven't seen it?
Right. I think that would be wise. Yeah, but I presume they're aware of it. Maybe they're.
We'll send it to a covering note and just ask them, just to make sure they're aware of it. Next item, 9.7, Public Accounts Committee. Members are asked to note at page 199 correspondence with the Public Accounts Committee, asking the committee to keep it apprised of developments regarding hard charging for the NICS state. We'll deal with that when we do the business plan again, I think.
If we ever do that, yes.
Yes. Yeah. Yeah. Are we agreed? Agreed. Fiscal Council. Members are asked to note at page 200 a response on access to budget information which is to be shared between the Fiscal Council and the Department. The Minister appears to indicate that the committee receives sufficient information from the Department of Finance and that it should engage with other committees and other departments if it requires sight of other information. Are we content to note? Content. 9.9 Northern Ireland Food Strategy. Members are asked to also note on page 208 a copy of the Northern Ireland Food Strategy Framework consultation. This has been shared as it makes limited reference to the procurement strategy which sits within the Department of Finance. Is the committee content to note? Noted. Composite request at page 247. Are we content to note the composite request is an accurate and complete record? Are we agreed?
Yep.
Agreed. Yep. Forward Work Programme. Next week we'll have briefing from the Assembly Research on the Financial Reporting Department and Public Bodies Bill. Peter has shared a bill folder including all relevant information with all members via SharePoint. An updated version will be issued on Friday. If members are unable to access this, please urgently contact the committee staff. Is the committee content for the clerk to write to the department setting out the queries and issues and suggested amendments in the responses to the call for evidence, and to ask the department to provide responses at the evidence session on the 13th of October 2021? Are we content? Content and agreed. Okay. The last day of the committee stage for the defamation bill is currently the 2nd of November. However, in order to allow time for stakeholders to answer the call for evidence and for oral evidence to be taken in November and December, it is suggested that the committee seeks an extension to the committee stage until Friday the 20th of January 2022, but endeavours to report sooner than this. Are we content?
Can I just ask, who's is it our proposal? Is it your proposal? Is it that we extend committee stage to the 20th of January?
It's my suggestion.
Your suggestion?
Yeah.
If you look at the forward work programme.
And if we just move down a bit, sort of, I'll explain one of the reasons why. Okay, so we're agreed to that. It's also suggested the committee writes to the sponsor of the bill accordingly. Are we agreed? Yes.
Yep.
Right. In respect to the defamation bill, Professor Andrew Scott is available to appear in person at the committee on the 3rd of November 21, and would be the opening briefing for the committee stage. Is the committee content to amend the forward work programme accordingly? And is the committee content? Agreed. And we also understand that Professor Scott lives in Belfast.
So we understand, yes. There you go.
As indicated last week, the committee will also endeavour to schedule before Christmas recess briefings on the Procurement Board, Fiscal Council on the Executive Budget, and the Fiscal Commission on its interim report. And I'm led to believe that the Fiscal Council has already done quite a lot of work behind the scenes as well, so this should be something substantive for them to talk about. The committee for the TEO has asked the committee to swap rooms on the 20th of October to allow it to accommodate a large number of witnesses. Is the committee content to meet in that room room 30?
Well, we are the most senior and most important committee. Should we be moving for these minions? I don't know. Maybe reluctantly so.
I shall say, could you refer to the chair of the committee of the TO that says reluctantly will agree?
Reluctantly agreed.
Right. The department appears to be indicating that it's not ready to share its submission on the respective October monitoring. And you think this is down to LRSS?
Yeah.
If members are content, consideration of this written brief will be moved to the 13th of October. Are we content? Great, thank you. And we're content with the forward work programme as amended. Great. Any other business? Okay, thank you very much indeed, team. Next meeting on the 6th of, and hopefully on the 6th of October in here at 1400. I hereby adjourn the meeting.
This is the Northern Ireland Assembly Senate Chamber programme.